Have you ever been at an IEP meeting or discussing special education services and somebody keeps saying FAPE? Well, this is FAPE, or this is what your child needs for FAPE, or this is how FAPE works. And you say, what is FAPE? Well, number one, that's a difficult question to answer. And number two, this video is for you. Ladies and gentlemen, boys and girls, YouTube, thank you so much for coming back. My name is Eli, I am the lawyer guy, and today we are going to be talking about a free and appropriate public education, or a FAPE, as many of you have heard it said. Now, what this is a very difficult question to answer. It's a very difficult concept to try to flesh out because there hasn't been a lot of direct guidance from the court system. What we need to look at first is, what is a FAPE under the IDEA? So, the term free and appropriate public education means special education services and related services which have been provided at public expense, under public supervision and direction, and without charge, meet the standard of the state educational agency, include an appropriate preschool, elementary, or secondary school education in the state involved, and are provided in conformity with the individualized education program. So you guys got that? All right. Thanks for coming. We'll see you next week. I'm just kidding. That's not quite going to do it, right? It's pretty sterile. It's pretty statutory, and if you look at it, it doesn't really answer any of your questions. Free and appropriate public education has to be free. It has to be provided in an environment that is a school, and it has to comport with your individualized education program, but it doesn't really say what your individualized education program has to say in order to be a free and appropriate public education. So, what we're going to do today is we're going to lay this out as kind of a timeline as to how we came to the understanding that we have today about what a free and appropriate public education is. Now, before 1975, basically, schools and school districts had the choice of whether or not they even wanted to educate children with disabilities. They had the choice to say, hey, you know what? You should probably just keep your kid home. I think that's better for everybody involved, and parents would do that.
Boo!
Now, right around 1971, 1972, some federal court decisions came in Pennsylvania and the District of Columbia, which stated that school districts did have to provide educational services to children with disabilities, and that was it. And those were the landmark decisions, because before then, they didn't have to do anything. In 1975, after educators and administrators, parents, stakeholders had been continuously coming to Congress and saying, look, we need some sort of a standard and protection for these kids with disabilities. Right now we have nothing. Congress came up with the Education for All Handicapped Children Act in 1975, and that was reauthorized in 1990, and with amendments and some additional things that turned into the Individuals with Disabilities in Education Act in 1990, which is what we have right now. There have been a few reauthorizations since 1990 which have added also additional protections, but that's kind of the timeline going into that definition that I gave you right at the beginning of this video, what a FAPE is. Up until 1982, from 1975 to 1982, the only analysis that would go into place when individualized education programs were challenged was, did the school district provide you with the services that were in your IEP? Yes, then they're fine. If they didn't, then they're not fine. Those are the only things. Never the substance of the individualized education program. And when a case did finally make it to the Supreme Court in 1982, the Supreme Court realized, wait a minute, we don't have any laws on the books, any case analysis about what needs to be in this individualized education program to make it a free and appropriate public education. And that case was the Rowley case. You've probably heard about the Rowley case if you've done any kind of analysis into special education laws, the seminal case that supports the free and appropriate public education standard. Amy Rowley was a first grader. She was hearing impaired, and she was in a full-day general education program. The school district that she was working with had provided her an IEP, had provided her with what's called an FM system to assist her with her hearing, and she was also very adept at reading lips. Now, Amy's parents came to the school district and they said, hey, she needs a full-day sign language interpreter in order for her to maximize her time in general education. The school district said, no, she doesn't need that. Right now she's doing fine. Our program is appropriate. So the parents filed a lawsuit. This lawsuit got appealed all the way to the United States Supreme Court. And in a 6-3 decision authored by Justice Rehnquist, for you Supreme Court buffs out there, the Supreme Court had to look at what is a free and appropriate public education, what is the right way to do it, and what is the wrong way to do it. Now, the reason why this had come to a head is because the parties here had two completely diametrically opposite understandings. One was Amy Rowley's parents. Amy Rowley's parents said that she needs a program that maximizes her time in general education. And the court said, no, that was not in the statute, and we're not going to put it in the statute. That is not the standard. School district was going by what those underlying court cases had already said, which is we're giving her the services that are in her IEP. So that's all we have to do. And the court said, no, you're not right either. It's not just whatever's in her IEP, and it's not maximizing her time in special education. So what is it? So the court came back and said, access to an individualized education that provides some educational benefit or a basic floor of opportunity. That is what is necessary in order to provide a child who is in general education with a free and appropriate public education. Now the court looked at it and they said, how are her grades? The district said her grades are good. The court said, are you implementing the services that are in her individualized education plan? She said, yes, we are. The court said, how is she doing with regard to the rest of the class? District said she's in the upper tier of her class. And so Amy Rowley's parents lost. But with that came the standard for children that are receiving special education services, a basic floor of opportunity, access to an individualized program. Those both came out of that case. So now, while we don't have a rule for every specific child, we do have a generalized rule where we didn't before. And that was the case for a very long time. Rowley was gospel in terms of free and appropriate public education. Now, in 1993, in Tennessee, another case came up, Doe versus Tullahoma. And Doe versus Tullahoma had to do with a child who had been privately placed by his parents. And the parents came back to seek reimbursement from the school district, and they said, look, you guys need to reimburse us because the private school has given him a much better benefit than anything you guys could have ever offered him. And the child in Doe versus Tullahoma had never been enrolled in the school district. And the school district said, look, we have an IEP here, we're ready to go, but you've never accessed it, and we don't believe that that's the FAPE standard. And what came out of Doe versus Tullahoma was kind of a famous colloquial statement regarding a parent's expectation of a free and appropriate public education versus the reality of what districts have to do. And the judge in that case said, the parents here want a Cadillac for their child, and Tullahoma only has to provide a serviceable Chevrolet. So Chevrolet is what they need to do. Parents, obviously, you're going to come in and expect the Cadillac, and you're just not entitled to it under the federal law. And that judge made that very clear with that analogy.
Boo!
So we've got Rowley, 1982. That was the law. Districts had to follow it. Parents had to kind of adhere to it. Now, in 2017, the Andrew F. case came down, and it was a big deal for the Supreme Court to take a FAPE case for people in the field. Because again, we had a case from 1982 that was the seminal case in our field, and that just kept rolling on. And in 2017, the Supreme Court took the Andrew F. case to determine the FAPE standard. Now, the difference in Andrew versus Rowley was that Andrew F. was a child that was not in general education. He was in a special education class. He had autism, has autism. And Andrew's parents, like Tullahoma, had placed him privately. But Andrew's parents, unlike Tullahoma, had taken the school district's IEPs for a number of years before they decided to place privately. That's a little bit of the difference here. Now, the court in Andrew F. looked at, okay, what are the circumstances with regard to a child who is not placed in general education, what are we supposed to look at in order to determine whether or not they're receiving a FAPE? The lower court, or more specifically the 10th Circuit Court, had said that mere de minimis progress is sufficient. That's a FAPE for a child who is placed in a special education program. And the Supreme Court rejected that offhand. They said, no, that can't be it, because de minimis is nothing. That's essentially the definition of de minimis. It's so minimal that it's trivial. It doesn't matter. And that can't be, because otherwise, why would we have a law at all requiring all these things if they're not required to provide this child with progress? Now, again, on the flip side of that, Andrew F's parents were saying that there's a standard here that needs to be adhered to that's higher than the Supreme Court thought. The Supreme Court said, no, you're not right either. It's somewhere in the middle. And where it is progress in light of a child's individual circumstances that is reasonably calculated to provide them with benefit. Now, the individual circumstances is really the biggest addition here. And you look at what is this child capable of based on assessments and their IEP, and have they made progress that's reasonable based on those circumstances? Not de minimis, also not the Cadillac over here, but this is what we're going to look at. In the case where we can't look at, are they moving from grade to grade? Are they achieving good grades like a child in general education would be? And so that's what came out of the Andrew F case. But again, the court here stopped just short of saying, we're going to address what appropriate progress is.
Boo!
They did not say that, and they specifically said they wouldn't say that because every child is so different. So the court in Rowley came about 25% of the way. The court in Andrew came about 25% of the way, but we're still about halfway in trying to really have something there that parents can hold on to say, this is what a free and appropriate public education is. And that's 2017, and that's the law right now. That's what's in place, a mixture of Rowley and Andrew F. So, with all that being said, what's the action plan here? What are we going to take from this? How do we use this, Eli, to help us in any way if it's so confusing? Well, the short answer is, if it's confusing to you, guess what? It's confusing to the school district as well. They don't have any more of a significant basis than you do as a parent to say, this is what FAPE is for your child. So you have that argument as well to say, okay, here's what I believe is FAPE for my child. And that is a discussion and an agreement that has to be made at that IEP level. And you don't have any less of a basis to make it than the school district does, because this standard is very fluid and it was intended by the Supreme Court to be fluid. So use that to your advantage. Have information at hand to be able to make that argument. This is what I feel like is FAPE, and this is why. And one of the biggest arguments you're going to have is if your child has not been successful for a long period of time in the same program. If your child has been in a special day class for years and years and they haven't been making any progress, guess what? That's Andrew F. That's why they were able to get reimbursement for their private school. It's because that program was not FAPE for him. So that is one of the benefits when you come into that IEP meeting. So number two, what we're going to be looking at is I will not be limited on time. I will not be limited on assessments. I will not be limited on any aspect of this IEP. If it takes 10 meetings, it takes 10 meetings. If it takes a dozen assessments, it takes a dozen assessments. So when they're coming to the end of that 1.5 hour window that they've given you and they plop that document down in front of you and say, okay, well, okay, these are the goals and this is the services and this, okay, so can you please sign consent? That is not going to be appropriate. You have to have that time to analyze, make your arguments, and come to a decision that is good for you as a parent that you feel like is appropriate. And that liquidity, that uncertainty as to that FAPE standard lends itself to the district not being able to say categorically, this is it, because it never will be. The court did not give us that level of certainty. And again, as I've always told you guys in every video, and I always will tell you in every video, you are the best advocate for your child. The school district personnel are going to rely on whatever it is that they rely on, and you'll never know what that is, but you know your child best. You have that experience. You have that heart and passion to be able to make those decisions and use that information to the best of your ability. The school district's never going to have that. The school district's never going to have that love and passion that you do. So you are the ones that have to take control, take the reins and say, look, I respect what you guys have to say, but I'm going to need some more time with this. We're going to need to have another meeting. You're going to need to do another assessment. You're going to need to have somebody else here, or I'm going to need to invite somebody else here to make this a better process. Because FAPE is not black letter law. It's not black and white. It's liquid. It's floating out there in the ether, and it's for you to be able to find that and make that agreement with the school. There is no one-size-fits-all program. There is no one-size-fits-all service. If the school district wants to put your child into a certain placement, then they have to explain that and say why that's appropriate for your child. Not for a child with autism, not for a child with cerebral palsy, not for a child with a learning disability, your child. All right? And you guys have to be the ones policing that. So please, be your child's best advocate. Take that time. You're owed it. All right? So that's it for today, guys. The FAPE standard, or lack thereof, really, and how it came to be, and how you're able to deal with that at an IEP meeting with an offer of free and appropriate public education. As always, thank you guys so much for tuning in. If there is a subject or any kind of legal concept, whether it be education law or something else that you'd like me to address, please leave it down there in the comments. Please leave me recommendations down there in the comments. And if you like our content, please subscribe and come back. We're going to try to do as many videos as we can, as often as we can. All right, you guys, have a great day. We'll see you next time.